Hey, good morning, everyone. I thought I'd put up a fairly quick review, and I know I'm not good at doing things quickly on these reviews, for Chapter 3 on Federalism for our political science U.S. government class. It's, I think, a very, very important chapter. I think some students find some confusion with this, but then when I bring out hopefully a few examples of why it's confusing, because it is on some levels, it usually breathes a little bit of life and understanding into the tension we have in what we call a federal system or federalism. It goes to the nature of how we have different governments in this world. One of them is called unitary, and that's a lot of them. Basically, power flows down from one central authority to the entire governed country. Um, that's the simplest to understand. Obviously, there are sub administrative bodies that administer laws and regulations and judicial outcomes at local levels, but they all are dictated from the top, a unitary system. And then there's other that are confederal, and that's what we had initially in our country from up until 1787, and it started at 1781, roughly, almost 8 years. And that was called the Articles of Confederation, because that's what it meant. We were 13 independent countries that agreed to share some resources and some oversight in narrow areas of governance. And that's a challenge, and it doesn't always work. And it didn't work for us. So we broke away from that, and we didn't. In a lot of what makes us unique is you're either one or the other. You're either a confederal system or a unitarian system. Few are what we are, which is called a federal system. Germany is also a federal system, and supposedly Great Britain is becoming more of a federal system. And what is a federal system? Sovereignty, which means power, is divvied up between two sets of authority. And in our system, one is the federal authority, and the other is state authority. And why do we have it? Some people say it's wonderful, it's beautiful, and other people are going to say it's awful. In fact, that's going to be your sort of your homework, is just to basically discuss the strengths and weakness of a federalist system. Well, why do we have it? Well, when we knew when the framers met down in Philadelphia, when the Articles of Confederation weren't working, they needed to create a new government for our nation for its very survival, whether it's from foreign intrigue or from just internal collapse. And something had to be done. And so, why didn't we go to a Unitarian system? Well, that's what we were kind of breaking away from. We didn't want centralized authority in such a big geographical nation. Again, remember back in 1787, it wasn't like we could communicate immediately with our government via the internet or the phone or the like. Back then, it took days, if not weeks sometimes, to communicate from one end of our country to the other. And there was a real fear that if we created a unitary system of government, tyranny would break out by those that were in power in a distant um, hub of government that wouldn't necessarily be in our home. If I'm down in Georgia and the hub of government's in Washington, D.C. or New York City, you could imagine how I feel like people are ruling my um, my community in almost an arbitrary fashion because they're distant and they don't know what's going on in my community. The other spectrum would be the confederal system. We're back down in Georgia. Let Georgia rule Georgia. Let Massachusetts rule Massachusetts. But then we're not what? We're not really a unified country, and we can't frame foreign, threats, and we can't deal with things like interstate commerce and taxation and a national coinage of money and a national defense with an army and a navy, not an air force, but that came much later. There was a speech recently by a certain politician that said in 1776, when the battles broke out, we secured all the different airfields. It's not really true. There were no airfields back in 1776. But anyways, American federalism broke out as a result of the compromise. I shouldn't call it the Great Compromise, because the Great Compromise is how we're going to um, create the legislature in terms of, is it going to be based upon the population of the state? You'd have so many legislatures, or is it going to be basically just by statehood? You'd get an equal amount of legislators. In the Great Compromise, that term has been coined to mean the Senate would be made up of equality between the states. No matter what the size of your state was in terms of population or geographically, you'd get two senators, and the lower house, the House of Representatives, would be housed with a number of representatives based upon your population. There's the great compromise. But I always call this also a great compromise, is states are going to give up a lot of their autonomy, their control, their sovereignty to govern themselves. And when you ask people to give up power and give up control, that's a difficult thing to do. And even in a personal level, right? When somebody asks you, let somebody, your representatives decide certain things in a distant arena, that's pretty scary. And so the compromise there was, okay, well, you're not going to give it all up. We're going to have a federalist system or federalism where there's a federal government that's only going to be given limited authority based upon enumerated powers. And the book does a nice job telling you where they're all found. And it's in Article 1, always stands for the legislature. Section 8 lists what the federal government will have power over. And it doesn't necessarily say it's going to be exclusive. We'll get to that in a minute. But basically the core ones, which were problematic under the Articles of Confederation, the federal government will have power to deal with things like the coinage of money. No state would ever be able to coin money after that. So all money would have a national significance and national backing. Taxation of tariffs with foreign nations, and no state would be allowed. This is one where the states were actually prohibited. States wouldn't be allowed to tax consumer goods or any other kind of goods flowing from one state to another, except if it was consistent with their own home state. So, for example, if goods came from New Hampshire and New Hampshire didn't have a sales tax, Massachusetts could impose a sales tax on it if Massachusetts taxed their own sales of goods. So there's equality in that process. A little technical, don't get too worried about it. But the point is, we want the federal import taxes to be controlled by the federal government. And we also want the federal government to have the power to tax so they can do things like infrastructure and roads between the states, and more importantly, protection from foreign threats, military, right? And so we have taxes, we have tariff and international negotiation. We don't want one state negotiating with France over some treaty. We want the whole country to do it, right? And so international trade, rules, taxation, foreign agreements, treaties, all of those things we said we're going to delegate to the federal government in Article 1, Section 8. And it's pretty clear that they listed these things, but it's not clear what does that actually mean. What does it mean to be able to tax? What does it mean to be able to regulate commerce? What does that all mean? And can the states participate in those things too? And sometimes that's called dual sovereignty, where the states can actually participate in some of those same questions. Some they're barred from. How do we know? How do we know which ones the state can participate on, which ones are just federal? Well, sometimes the Constitution spells it right out. One, I thought it was pretty clear, but there was some debate about it, and that's immigration. Immigration is controlled in Article 1, Section 8, that Congress shall determine the rules for naturalization and immigration. And so they can determine what it takes to become a United States citizen, how much immigration will allow, what the rules are. But some states were dissatisfied with that, and they wanted to participate. Namely, one significant one was Arizona. Arizona was, they thought they were plagued by illegal immigration, so they thought they'd enforce their own immigration rules. And that went all the way to the Supreme Court, their argument being, we're not in conflict with federal law. We are trying to enforce federal law that the federal government's not implementing or doing a good job on. Supreme Court said that when it comes to immigration, the federal government is not only supreme, and we know there's a clause in the United States Constitution. I always think it's Article 6, but sometimes I think it's Article 4. I never remember things that so well, and I don't expect you to. That's why I think if this were a regular brick and mortar class, I always give open test books because of that specific quality. It is Article 6, I was right. So it's Article 6 supremacy clause, and there it says that if the federal government does have power to delve into a certain area, like taxation, immigration, coinage of money, raising of navies and armies, then if there's a law from a state or local municipality that conflicts with it, the supremacy clause says basically the state jurisdiction needs to be null and void in that arena. Okay? That doesn't mean they can't necessarily, in some realms, also participate. And there's where the confusion lies. So that was a great compromise. Hey, we're going to have two sovereign bodies, state and federal. The state's going to control some things exclusively. The federal government's going to control some things exclusively. There's going to be an overlap when you think of concentric circles overlapping each other. There'll be some areas where both can get into. And the question remains sometimes is, well, which? Which is it? And the answer is not always clearly in the Constitution. Who tells us who's right and who's wrong? the courts. But that comes later. We haven't gotten to the judiciary yet, but we're going to go into this famous case called Marbury versus Madison, where the Supreme Court basically says when we interpret something like the Constitution, that's a law, and courts are the branch that is designed for jurisdictional outcomes in that arena. So when the court, especially the Supreme Court, interprets what the Constitution means, is this federal government only? Is it state government only? Is it both? It's always determined by the Supreme Court of the United States in the final analysis, or by us if we want to amend the Constitution. But when we get to that chapter later on about amending the Constitution, we know we don't do it very often. Even if there's a lot of excitement over a question, it often dies down because of the major hurdle it is to amend the Constitution. We've only done it really 17 times. People say 27, but the first 10, the Bill of Rights, came as a package, right? So federalism is the shared governance between federal and state. And so can the federal government pass any law they want as long as the Congress says we want this law, the president approves? Can they do it every single time? No. It has to be from those lists of enumerated powers. If they don't have the power, they simply can't do it, even if it's a good thing. I'll give you a little bit of an example. Some of you might remember a woman named Terry Schiavo. She was down in Florida. She was on life support machinery and things like that. And her husband thought her wishes would be, even though she didn't have a legal document saying so, and her and her husband were arguably estranged. That's another set of facts. But basically, the husband went to court and says, we want to end these extraordinary life maintaining interventions and let her pass. And he went through the Florida court system, and this became very controversial because her mom and dad, and I guess her brothers and sisters, wanted to keep her alive. But her husband says, it's just really time to let her go. The Florida court system said, no, the husband has that say, and gave him the authority to basically, I hate to say the term, but pull the plug. And then they took it to the federal courts, and the federal courts said, we don't have any jurisdiction in this question. It's a state law question. But believe it or not, almost overnight, the federal Congress, the United States Congress of the United States, both the Senate and the House of Representatives, passed a specific law to keep her alive. And President George Bush the Younger at the time signed it into law. Well, the husband of Terry Schiavo brought it to the Supreme Court of the United States saying, it's not about the merits of the law. It's not about whether it's wise or unwise. It's whether it's constitutional. Does the federal court the federal government have the power to act in this area? In the Supreme Court of the United States, I think it was a unanimous decision. And it wasn't about whether it was right or wrong to keep Terry Schiavo alive or take her off life support. It was about whether or not the federal government had the authority to delve in that area. And the Supreme Court said they did not. They're supposedly a government of limited authority. And the book does a nice job on this. Has the federal government's authority grown exponentially? Yes, no question about it. And somebody can say, well, how could it? It's in the Constitution what they can delve into. How can they possibly expand it? Because the list of things they were given power over are in generalities. They're a bit vague. What does it really mean to have these powers? And so they're also given a special clause called the Necessary and Proper Clause and the General Welfare Clause to basically say, here's the list of things the federal government can do. This is their realm of authority. And then there's this thing called the Necessary and Proper Clause that says, and all necessary laws to implement those listed enumerated clauses. That's given a large breadth of authority. Why? Because the Supreme Court said so. And it started with a famous case called Maryland, Murdoch versus Maryland. I think I have it right there. I always say that name wrong. Justice Marshall is one of my favorite characters in history and in political science. I don't know why he's not on. Well, he is on a coin, but on a coin that we exchange daily. But in Maryland, in the Maryland case, we had a situation where the President of the United States at the time was a fellow by the name of George Washington. You might have heard of him, right? He was talking about potentially making a McCulloch versus Maryland, a national bank. In Hamilton, his Secretary of State at the time, real genius in terms of wanting to create this country into like a real commercial interest and stuff like that. Thomas Jefferson was his in his cabinet as well. And Thomas Jefferson said, no way, the Constitution doesn't say anywhere the federal government has the power to create a bank. No way, we're not going to create a national bank where national monies will go into and things like that. And Alexander Hamilton says it's necessary. We're collecting taxes, we're minting money, we're dispersing funds. We, ancillary to that, related to it, necessary and proper to it, would be to create a national bank. So George Washington was kind of taking both of their advice. They really disliked each other. Hamilton and Jefferson, there's a long history there. They actually help each other later on because they hate a third guy even more, a guy named Aaron Burr. But anyway, so Washington goes along with his trusted aide, Alexander Hamilton, and he creates a national bank. And what do? They open up a branch down in Maryland. Well, the state of Maryland taxes the living hell out of it. Why? Because they don't want the national bank to compete with their state banks. And so McCulloch, who was the head of, I don't know, the Federal Reserve or whatever it is that runs the federal banking system at the time, challenges the state of Maryland to say, not only can't you tax it, but you can't interfere with us in any way, shape, or form. And so they took it to the United States Supreme Court, and John Marshall, again, this great interpreter of our document, what we call the U.S. Constitution, turns it into a federally dominated document. There's no question. I don't know if that's what the framers intended, but that's what John Marshall certainly believed. And John Marshall prevails because we followed what the Supreme Court said under this concept of judicial review. And what does he say? There was two questions answered by the McCulloch case. The first one is, does the federal government have the power to create a national bank? He says, yeah, it's not listed overtly, but we have the ability to tax, we have the ability to raise revenue, we have the ability to place tariffs against foreign goods and imports, we have the power to regulate commerce. All those things are somewhat related to banking. Banking would certainly help us in that role as a federal government, so therefore the federal government does have the power to create banks. And the second question was, could the state of Maryland tax a federal branch sitting in Maryland? And McCulloch, my favorite quote, one of my favorite quotes of John Marshall, he says, the power to tax is the power to kill. And if the state can basically impede or interfere with the federal goal that the federal government has the power to do, it's null and void. And they're under the Supremacy Clause, Article 6 of the U.S. Constitution. So under John Marshall in the Supreme Court, case after case after case gets challenged in what is the results, not universally, but pretty close to universally. There's occasionally pushbacks, and the book does a good job talking about all the way up into modern times. Has there been pushbacks to federal domination? Yeah, sometimes the Supreme Court comes down and says, hey, federal government, like the Terry Schiavo case, or another one dealing with gun regulations near schools. They said there's just nothing in the Constitution that gives the power of the federal government to regulate the possession of guns near school. Commerce Clause not related enough, Taxation Clause related enough, coinage of money, those things are not related enough, immigration not related enough. They couldn't do it. So that law got shot down related to handguns in a school zone, got shot down as a federal law as being unconstitutional. Not because it's wise or unwise, but because the court just simply couldn't find a tangential basis in the enumerated powers. But overall, what should you get from Chapter 3? That the federal government's power is limited, but is expanded greatly because of the enumerated list of powers are quite broad and vague, and the necessary and proper clause has given the Constitution a very broad interpretation of what those powers are in the federal level. But can the federal level be the only level? No. Some things the federal government just stays out of, or at least over time has stayed out of, and sometimes that evolves back and forth. One of them is marriage, for example. Federal government had basically nothing to do with marriage for the longest period of time. Marriage was always under state law because we had shared governance, federal on some things, state on others, and overlap in some areas. So for the longest time, states regulated marriage. Some states allowed marriage very early, in terms of age. Other states said it you have to hit a certain threshold, like 18 or 16 or something like that. Some were very young. And there's all kinds of criteria, how close you could be related to people by blood or marriage. It's called affinity. Those were all state, and they differed from different state to state. How it really became apparent is when gay marriage started becoming on the forefront of the political realm. Some states were allowing it. Some states were overtly banning it. And then, ironically, it was President Clinton. A lot of people think of him as very liberal on issues like gay marriage, but he wasn't. He said, because it was such a controversy in the nation, we need to pass a law that states be respected in their individual ability to govern the jurisdiction of marriage. So states were free to reject another state's provisions. So if you got married in Massachusetts, because gay marriage was allowed in Massachusetts, and you move back to Mississippi, could Mississippi basically say, we're going to reject and not acknowledge your marriage as legitimate? Yeah, that was called the Defense of Marriage Act. Well, most of you know the story. Many of you maybe don't. Eventually, somebody challenged the state law on marriage through the federal courts, arguing that the 14th Amendment, when we get to the amendments, we'll get to that the equal protection, if gays and lesbians are an identifiable group, all identifiable group have the same rights that are fundamental to all other people, regardless of which state you lived in. And that's what their argument was. And it went to the United States Supreme Court. And under the Hodges case, the Supreme Court of the United States said yes. So it federalized something that was always previous to that regulated by the states, and that's marriage. Now, most marriage issues still are regulated solely by the states, but which one isn't? The right to marry as a heterosexual versus a lesbian or a gay person. You have the right to marry, and that's established under the federal Constitution, under the 14th Amendment of the United States Constitution. But there's other things that are federally regulated and some things that are still state. Most educational standards are state. Somebody can say, wait a minute, you're talking about educational rules are state. I thought the federal has all kinds of mandates. Well, is there anything in the Constitution that talks about the federal government having the power over education? Does it do with commerce? Does it do with taxation? Does it do with the coinage of money? Somebody says, well, it's in the General Welfare Clause. But the General Welfare Clause is only to interpret those other enumerated list of powers. This gets to a very important concept in the book, and I thought it did a really nice job, is the federal government has a lot of money. And like anything else, states often have goals and interests to benefit their citizens. Big part of it's education. So think about it. If we're the state of Massachusetts and the federal government says, we'll give you millions of dollars, state of Massachusetts, provided you spend it in a certain arena in schools, okay, we'll take it, great. But then what they do is they put a list of requirements on those grants. And they'll say, yeah, we'll give you millions and millions and millions of dollars, but you have to teach certain things about math and science, and you have to meet certain curriculum goals and certain testing standards for that money to be renewed or to be given to you in the first place. And so the federal government has a lot of power over states, not through the Constitution, but what we call through a carrot, meaning the carrot being the enticement. Most of us aren't enticed by carrots. Carrots aren't, it should be like, I don't know, a cannoli, right? We're enticed by a cannoli, or I was going to say carrot cake, but my kids hate carrot. I'm trying to think, candy or something like that. The government often seems, the federal government often seems to make us do things, but it's not so much through the stick, meaning being whipped with a stick or poked with a stick, being punished, because they don't always have the power to do that, but they often do have the power to give us or withhold money from us if we don't follow certain jurisdictional things. Like right now in the United States, is it pretty much universal the drinking age is 21 years of age? No. So that's a federal standard. But where under the federal law does it have the power to do that? Some might say under the Interstate Commerce Clause, because we want to have consistency between people driving from one state to another. Pretty thin argument. It's not. That's not how they did it. How did they do it? There's a ton of money that comes to the states for your highway funds. Roads and bridges that it costs us a fortune to maintain. We can't do it with our own state funding. So how do we do it? The federal government says, we'll give you lots of money for it. But what do they want? They want to standardize things related to the drinking age. And that's how it happened. Some of the last holdouts were saying, we're not going to. And same with the speed limit thing for a long time. Everyone wanted to reduce their speed limit back. I think it was in the 70s or 80s when I was a kid. I remember that was a big issue. Some states wanted to have speed limits of their own because that's nowhere in the Constitution. Federally, the federal government's going to dictate what the maximum speed limit will be in my state. Where does it say that in the Constitution? It doesn't. But they were going to withhold highway funds. And this is back when the big gas embargoes were going on. They were trying to reduce the amount of fuel consumption, and supposedly when you drive a little bit slower, you don't burn as much gas. So they had a universal. At one time, it was universal in this country, 55-mile-an-hour speed limit. Why was it universal? Because of a federal law? No, because federal said you're not going to get money for the state highway programs and byway programs and bridges and things like that and infrastructure unless you reduce your highway speed down to 55. And later that came up to 65. I don't even know if that's part of the package anymore because I think some states are even getting a little more different from that point. But so the federal government has grown exponentially in power. The anti-federalists, those of you, I don't know if I put it on this class or I also teach U.S. constitutional history and I also teach U.S. History 1. And sometimes I think it's all related. And it is all related, but sometimes I think the classes are on the same topic. I think I asked on a homework assignment or a test question, who was right, or on a discussion board, who's right? Were the Federalists right or the Anti-Federalists right? Not right in terms of what would be better outcome for America, but what was going to happen. Would the federal government become dominant and the state governments become really a backseat authority on smaller issues? In the Anti-Federalists, in my opinion, you guys haven't participated in the discussion board yet, can certainly jump all over this. My opinion, uh, the Anti-Federalists were actually correct in terms of their prediction. The federal government did become omnipotent, not just simply because they had the power to do it in that written document, because they don't. Their power is fairly limited in the written document of the Constitution. How do they become powerful? Is through money. Is through basically incentive practices. Think about it. If I'm in the state of Massachusetts and the federal government's going to offer me a ton of money, and then they say, well, you got to do this, you got to create this standard or this law, what are we likely to do? We're likely to work with them because money talks. And it's sad, but maybe it's good too, because I like things being consistent throughout my country. I like the fact that when I drive from one state to another, the same concepts are not on everything, but on some things, I like them to be somewhat consistent. And that's the argument against federalism. We create 50 different jurisdictions with different rules, and they can be quite significant. The book does a nice job of talking about what powers are in the states, and those are called reserve powers. And the framers were so scared, the anti-federalists especially. I kind of think of I'm an anti-federalist on one level, meaning that I didn't want a lot of power going to the centralized government. And so they were so fearful of it that they put in the 10th Amendment to the United States Constitution, the Bill of Rights, basically saying whatever rights or laws or power we gave to the federal government, those are listed in the enumerated sections of the Constitution. Everything else is reserved to the states, even if we didn't list them. They're all reserved to the states and to the people. And arguably, the Civil War, although over slavery, there's no question it's over slavery, but the backstory to it, it's over state rights versus federal control. The Civil War doesn't end to the debate about which party can be dominant. Because for a long time, right up to the Civil War, there was an argument if the states were unhappy with what the federal government was doing, the states could nullify, and that's the term they used to use, could nullify federal law. And that debate was existing for a long time. And even some of our framers debated that was true. Guys like Thomas Jefferson and James Madison actually argued in something called the Virginia and Kentucky Resolves that the states were free to ignore federal law if it was repugnant to their state's philosophy and beliefs. Can you imagine that today if you said that? Because we don't like what the federal government's doing, even though they have authority in the area, so we're going to ignore it. No, the federal government can come down and squash it, and they'd have the power and the right to do it. But what things are still reserved to state? Things that are intrastate, meaning internally within the state with regard to commerce. To conduct elections, even federal elections are conducted by state laws in terms of eligibility and things like that. Some states allow felons to vote, other states don't. And that's kind of interesting. A lot of people say, wow, it's kind of weird. I'm going to vote in the federal election for the president of the United States, but my state's going to determine my eligibility for voting. Kind of interesting. Public health, safety, most police departments. In fact, most criminal laws. Some of you are CJ majors, I think. I think a big chunk of you are CJ majors. You have to take POL 211. And what's interesting there is almost all criminal law is state. So, well, what about federal? Federal makes up about 5%. And why does it seem bigger? It's because obviously federal criminal cases take on a national significance, and that's why they're enumerated in federal. They got to be related to federal jurisdiction. So usually state lines have to be crossed in some way, two or more states, intrastate, right? Or it has to be enumerated something about coinage of money, counterfeiting of money, for example. It has to do with treason against the government, basically terrorism. Other than that, most things like drunk driving and drug possession and distributing within the state, those are all related to state law. And 95% of all criminal cases are, in fact, state jurisdictional. So that's called police powers. And I don't like to call police because they all think criminal, but it's beyond that. It's health and human safety. All those things related to that are in the reserve powers of the state. The National Guard, the militia. Oh, and they contain some power against the federal government still, in that they can ratify amendments to the United States Constitution. So if someone says, hey, we need to change the United States Constitution, the states participate in that directly. We need 3/4 of the states to approve an amendment to the United States Constitution. Pretty difficult to get. And some that are, what does concurrent mean? They're shared. Power to tax. I have income tax. I live in Massachusetts. I have both the state tax and federal tax. There, it's not deemed in conflict. Borrow money, states can do that. Make and enforce laws. Courts, there's federal courts and state courts. This only happened to me once, but I had somebody say, I got a case coming up next Wednesday. You can represent me. I'm like, yeah, sure. And I say, I always want to get there early. So show up about an hour early. I'll talk to you outside the court with a cup of coffee. We'll talk about just arraignment. Biggest deal, but I want to talk to you ahead of time. And I'm out there and I'm looking for this person and I'm texting or calling. That was before texting was a big. I'm calling, goes, yeah, I'm out here. I don't see you. I'm here. I don't see you. They were at the federal district court. I was at the state district court because I assumed it was a state case. It was a federal case. Why? Because we don't always know if something's a federal question or state, and it can be both. Sometimes someone's charged with a federal crime, may also be a state crime because there's concurrent and overlaps. And some of you are saying, well, when do I know? Relax. You don't always know the answer. And that's the things we have to examine. And that's the tension and conflict. I don't mean conflict because we're going to beat each other up over it, but a conflict of understanding is when is there overlapping jurisdiction between the two entities and when is exclusive, when is not. Very interesting stuff. Take property for public purposes called eminent domain. And again, Article 6 makes it that the states are in fact secondary to federal government. If it's in conflict with the federal government, if the federal government has a role to play, it is going to make the state law or practice null and void. The other is something called the comity clause, sometimes also called the full faith and credit clause. That's Article 4 of the United States Constitution. That basically says no state can really discriminate against any other state. It's not an absolute principle, but generally speaking, if I have a judgment from Massachusetts or I have a valid marriage from Massachusetts now, it's going to be totally enforceable and recognized in every other state in the union. That way we can have some consistency under rights. No state is going to basically favor their own citizens over out-of-staters. Now, it's not absolute, and this came up when I was a young person in law school. I live right on the Connecticut border here, and there's a state park called Bigelow Hollow down the road here. It's really nice, and me and my sister used to go down there all the time. And if you went on a weekend, it was like, I don't know, it's pretty. Now it's pretty expensive, like $15 for out-of-state cars to get a parking spot. And in-state cars are either like free or $2 or something like that. And I remember saying, wait a minute, I'm studying the comity clause. I hate that term. It sounds like comedy. But the full faith and credit clause, how can they discriminate against somebody from another state? That's a violation of the U.S. Constitution. No, because like most things like free speech, most things in the Constitution are not absolute. There are parameters when there is a bona fide governmental interest in it. And what is that? If they charge the same rate for everybody out of state, there would be no so benefit from being a resident within that state. And just like that, I want to go down to Connecticut and vote for the Connecticut State Senate. I can't vote in their Senate, the state. I don't live there. I don't reside. So their citizens arguably have a better benefit by being residents of that state. Same with colleges. I was thinking about going to University of Connecticut Law School at one point because I don't live that far from it, relatively speaking. And the tuition was going to be pretty expensive because I don't live in the state of Connecticut. And I'm thinking, wait a minute, isn't a violation of the full faith and credit clause? No, because they have an interest in supporting their own citizens more. It's not really considered penalty, and it's a reasonable discriminatory tax. Like all discrimination is not illegal. That's one of them. You can discriminate on things like fees and costs related to the functioning of the internal workings and beneficial, the beneficial progress of its state. Some of you might be hunters or fisher people, and I've done this before. You try to get a license out of state. It's much more expensive to get a hunting or fishing permit if you're not a resident of that state, and it can be very, very expensive, quite frankly. So the comity clause is not absolute. But one of the things that comes up, and it's a great question I'd like to have in class, don't forget about John Marshall. You got to talk about that. And you got to talk about the McCullough versus Maryland case. It's big for test questions. And I don't like the theories that come up all the time. Well, we started off with dual federalism, then we got the cooperative federalism under FDR. I just think it ebbs and flows in different fashions at different times and different needs of our country. And there is a backlash, but some people always like to talk about this Morton Grodzin's famous layer cake, different powers flow at different levels in a cake, as opposed to like a marble cake. And it's obviously more of a marble cake. And his theory is it's more complex and more discerning. Sometimes it's in conflict, sometimes it's in harmony, sometimes it's cooperative, sometimes it's competitive. I think it's a pretty easy theory just to make. Grants are very important. I've been involved in some grants, and that's how the federal government gets to dominate states even further. And I don't mean dominate necessarily in a bad way, but if the federal government is going to give money, they sometimes create grants. And I think the book did a nice job describing the two kinds of grants. One are called block grants, which are very rare now. The other had a term, and categorical grants. Most are categorical. I hate that term because it like throws you off. What do you mean categorical? Grants with a lot of strings attached. We'll give you money, but you got to meet these very strict standards and reporting information back to make sure. You just don't want to give me money. Otherwise, I'm going to buy, solid gold glasses, and I'm going to have little helium balloons because it's going to be really heavy to keep them off my bridge of my nose. Come on. The government doesn't want to just throw out money. That's what block grants were largely. It was thrown at a general goal, and states and local governments could do whatever they want with the money. And oftentimes, the feedback was, it got wasted, is the argument. Sometimes it didn't. Block grants, I think, sometimes can be very successful. But I have to admit, it's like giving my kids money, and they're supposed to, okay, get ready for school. School's starting up. You need some stuff. Here's a bunch of money. Go get what you want. They're going to come back with a new Xbox game, and I don't know what young people spend money on, but whatever, subscriptions to Apple Music and some new headphones from this thing called Turtle something. I don't know, or ear beats or buds or something that don't get connected to wires. I don't know. They're not going to buy pads and papers and scientific calculators and things like that. But if I did it that way, I say, here's money, but here's the list of things you can spend the money on. That's a categorical grant. Grants are very, very powerful tools. In fact, the amount where you guys are at and I'm at, part of its survival financially is based upon getting grants from both the government and from private institutions. So I think it's kind of interesting. It's the incentive program. Unfunded mandates. That's basically the federal government, when they do have power, say states or local governments, you have to do this. And the complaint is, well, how are we going to pay for it? Because usually when you have to do something, it costs money. If the federal government has the power to regulate in that area, it relates to commerce, it relates to governance of interstate commerce, taxation, coinage of money, immigration, then you do have to do it. And it's a big complaint, and local governments can be very expensive. The book does a nice job of talking about all these different ways in which taxes get raised and where they go to. And the bottom line is federalism good or bad? I know I'm going really long. You guys can zone out when you listen to these things if you listen to them at all. But one of the fascinating things is marijuana is a perfect example of the complexity of federalism. Right now, Massachusetts has legalized recreational marijuana. I think you have to be 21. I don't know. And I remember my son, I was going down with him. He's 20, and we're driving down in Leicester, Mass. And it was the first night that I think it's called Cultivate was open on Route 9. I have a law office in Worcester. Sometimes I take the road back, and my son was in Worcester at the time, so I'm giving him a ride back. And so, oh my God, there must be an accident. All kinds of police lights are on, and there's all kinds of activity, and the traffic's really slowing down. I said, oh boy, I hope it's not a fatality. And my son goes, nah, Dad, it's opening night of Cultivate. I said, opening night of Cultivate? What's that, like a concert or something? He goes, no, the marijuana shop. It's one of the first ones in Massachusetts at the time, a year or so ago, maybe 2 years ago. And I couldn't get over the hoopla over it, the excitement over it. And my son goes, I'm glad the government finally. I said, which government? And he goes, all the governments. It's now legal for people over age 21. Very, he liked it. He thought it was a good thing. Shouldn't have criminalization of something that's similar to drinking. That was his philosophy. I said, yeah, but it's still illegal federally. What are you talking about? Because right now, if the federal government wants to come down, because they have jurisdiction, the Supreme Court has held that the regulation for the general welfare of the public is to criminalize certain kinds of drugs that are deemed harmful to society. Marijuana is still on the list. Could the federal government come down and shut down Cultivate, seize its assets, charge the people possessing and running and selling those drugs? Yes. People say, wait a minute, but the state government said yes. But if the federal government has the power, does it trump the state government? Yeah. And then you have this tension out there. There was real concerns when Jeff Sessions was the Attorney General under Donald Trump. Could he come down and basically make the Justice Department shut down those states that legalize marijuana for recreational and or even for medical? Yes, they could have. Did they? No, there were some veiled threats they might, but they didn't. But they still had a lot of problems with banking because under some of the federal laws, if banks get money that they have a suspicion is related to drug activity that's illegal under federal law, they're supposed to seize it. And so there's some bank, I don't know how to get around. I don't know if they're just using state banks. I don't know how that works exactly. But there's those things. The other thing that confuses and makes it complicated, think about those of you that are into guns or not into guns. I have some guns and I live on the Connecticut border. I am licensed in the state of Massachusetts to carry a concealed weapon. Does that mean I can drive down to Connecticut and go, hang out with my friends at a picnic? And like any good picnic, you should carry a gun with you. Can I do that? No, it's not a wise idea either, in my opinion. But anyways, can I do that legally? No, because I'm not licensed in the state of Connecticut. That's the quandrum of federalism. We don't have a federal licensing system because guns, in terms of some basic principles, aren't federally regulated. There are certain background checks, but other than that, most gun regulations are state. Boy, it does create some very, very real complications, doesn't it? The kinds of guns you can own, different from state to state. And so I think that's part of the drawback of federalism is where you live may be very different in terms of the laws that are implicated. And it also creates some beauty in a way. For example, if I don't like the way in which laws are promulgated and passed in Mississippi, what can I do? I can move to a state that has legal applications that I think are more related to my philosophy. It's called voting with your feet, if you will, or civics through movement. And there are different cultural and different societal viewpoints depending on which portion of the country you live in. And are we really one country is what you have to ask yourself. Does federalism create a certain kind of tension within the country to create different areas of application of law? And there's no question it does. And I'm a big fan of equal application of law and consistency through law, but federalism is in direct opposition to that. There's a federal standard, but again, like in criminal law, like I practice, some things that are legal in Massachusetts might be a crime in another state. And it creates an argument that equal justice under law should have consistency from one state to another. That's my little bone against federalism. What's my thing that I like about federalism? Home rule. I want to be represented from within my community and want my community members to dictate how we've decided to be governed. I don't want it from the federal government too much. I want the federal government to be small and kind of stay out of the way for most practical things. But then I go travel and I might find it very, very different in different areas of the country. I have relatively young kids. My daughter is 23. I have a 21-year-old. I'm sorry, 22 now. 24, 22, 20, 15, and then of course my stepkids are 22, 18, and 16. I worry about them because I don't try to micromanage. I tend to be a pretty lenient guy, but I worry about like marijuana. Like, you go down to a different state and these kids travel and they go different things. I said, Massachusetts might treat you very differently than if you're in another state. And you got to be very, very cautious about these kinds of things because of federalism. And I was all over the place today, but federalism is all over the place today. I hope you watch this thing. It's a bit long. And if you have any criticisms, well, I guess I'll take compliments too. But if you have any criticisms, hey, I'd like to see more of this or more of that in the discussions, I'd be glad to try to accommodate you moving forward. But that's chapter 3. I would like to say in a nutshell, but it wasn't. I was all over the place. But the book is very, very good. But if you have questions, don't be afraid to shoot me a text, give me a call, shoot me an email, and we'll have a further discussion in those areas that you feel a little bit maybe uncomfortable with. And there's a lot to be uncomfortable with in our Federalist system. Take care.